I welcome you all in the room and online to this seminar, which is brought to you by the Garden Court Children's Rights and Education team. The focus of our seminar today is essentially an update on schools' exclusion law. That's permanent exclusions, but then also looking at other forms of quasi-exclusions. And this is a law and practice update. We're going to hear from a number of panel members. I'm going to start off with, my name's Stephanie Harrison KC. I'm going to start off with an update on access to legal aid for independent review panels. We're then going to hear from Nicola Braganza, who's going to focus on child criminal exploitation and the relevance of Article 4 in exclusions. My colleague Ollie Persey is then going to speak about discrimination in judicial review and the intensity of review. We're then going to hear from Etienne, who's going to focus on an element of quasi-exclusion, which is isolation rooms. And lastly, we'll hear from Alex Temple, who's going to focus on disability discrimination claims in the First-tier Tribunal. So we have seen a number of significant developments recently in case law on permanent exclusions. We like to think that this is in part because of the work that we've been doing at Garden Court since 2021, when we established the Schools Inclusion Project, which was an attempt to bring together lawyers, community-based organisations, parents and legal representatives, both in private practice, but in particular in law centres, to provide greater access to legal advice and assistance for parents and children facing exclusion. And it's marked that in the last 12 months, there have been 3 Court of Appeal cases in circumstances where there had been no higher court authority. And pretty much it was a sort of black hole for regulation and oversight by the higher courts of what was happening, in particular in IRPs. And as it turns out, all of those cases involved barristers from Garden Court chambers. So to that extent, we feel that the aims of the Schools Inclusion Project, which wasn't just focused on barristers and work in Garden Court, but was on spreading out knowledge and expertise and ability to take up this really important area of law. We know how significant school exclusion is in the lives of young people who are subject to this process. We know that it results in poor attainment. We know that it risks not just social exclusion, but also exposure to criminal exploitation and even the very close connection and disproportionate number of young people in prison have been excluded from school. So it's obviously a matter of great significant public interest. It is mentioned in the white paper that came out yesterday, relatively briefly, despite the fact that we know that there's a close correlation, a disproportionate number of children who are excluded have a special educational need, which has either been undiagnosed or has not been properly catered for. So I think it's making some of the right noises. It's talking about preventing exclusion, but it's also got that kind of balance about behaviour and the need to manage behaviour. But this consultation that was issued, the white paper that was issued yesterday, is open to consultation. So for all those interested in this area, it's something that we could think about intervening. In particular, there's to put our experience of school exclusion and to be seeking a policy. Obviously, one of the aims of the School Inclusion Project was to secure a commitment to no exclusions and to have properly inclusive education. If one of the government's main proposals is that we should be mainstreaming of special educational needs rather than it being contracted out to separate providers, or it's got to be the school itself is capable of doing it, obviously needing the money to do it. But if that is the case, then really there should be, with that, some greater restrictions on the power to exclude from school permanently. And certainly it's a policy aspect of the work of the Schools Inclusion Project to engage in policy. So if you're interested in following up on that, that could be something that we would do. It's a really important opportunity to engage in this space politically, and I'd hope that we might be able to take something forward. We'd obviously also want to focus on the disproportionality in terms of those who are from Black and ethnic minority groups and Gypsy and Traveller, children who are disproportionately excluded from school. There's an aspect of recognition of that in the white paper, and the I didn't know exactly what it is, but the Race Equality Unit, which looks at broad government departments, is engaging in it. So it is an opportunity, and I hope that we'll take that up. But if I can speak then first about the topic that I'm going to talk on, which in some respects might be the most important topic, because certainly as far as representing young people and their parents in the process to prevent exclusion, funding for that work is obviously a priority. And we had set it as one of the aims of the Schools Inclusion Project to try to establish public funding and an extension of public funding. Anisha, you just put up my first slide. So one of the areas of work that I've worked on with Ollie and with first with Just for Kids Law and then Quorum and solicitors there, Sabrina Simpson, was about how can we get an extension of exceptional cases funding for IRP hearings. And there was this eventually resulted in a judgment, which you should, if you just put up the next slide, just set up there, the CWJ and the Director of Legal Casework and the Lord Chancellor judgment is 2025. And essentially what the court was having to address was what at that time, when we issued the proceedings, was that it was a blanket no. There's no funding for IRP hearings in the school inclusion context. That was in the Lord Chancellor's guidance, so the sort of safety net of Section 10 of the LASPO was not being able to be used in this particular area. However, during the course of the proceedings, after we got permission, being supported and funded to do that by the Equality and Human Rights Commission, the Lord Chancellor did in fact change the policy and made a concession, which added for the first time, as you'll see on the slide at 8.2 of the ECF guidance, that it would be possible for exceptional cases funding to be made available in a permanent exclusion case if obviously if it involved the determination of civil rights and obligations, but identified how that might arise is a strange, relatively opaque formula. It said the particular facts of the exclusion is arguably disproportionate restriction on the right to an education under Article 2, Protocol 1 of the ECHR, that's the right to education. And if such exclusion arguably gives rise to a right to a judicial remedy under the applicable law. We went a bit, what exactly does that mean? But what it basically means is that first, what's the most easiest thing to understand is that if you can establish in your case that it's arguably, I mean, that's important, it's only an argument for this stage, that there's a disproportionate restriction on the right to education, that could be funded. And what that might means in practice, as we've sought to subsequently deal with that, is that essentially any decision to permanently exclude that doesn't properly take into account relevant considerations, such as the special educational need or a race issue, or any other significant factor that could have meant there was an alternative to permanent exclusion, that will be a disproportionate interference. And so it's crafting your grounds, because obviously the IRP applies judicial review principles. So you've got this kind of combination, although human rights and discrimination are also part of it, but the sort of classic human rights principles that we're primarily concerned with didn't take something into account or came to an irrational conclusion, because they failed to take something into account, then that all can feed into why there's been a disproportionate interference, or at least arguably, with the right to education. But what is quite important in these cases is to make sure that you show that what the impact. So it's not simply that if you could just go to another school and there's no problem with that school, but you still want to fight the exclusion, they will argue, the Legal Services Commission will say, well, it's not disproportionate. You've got no right to education in a particular place. That was the previous case law. And so what you need to show is, well, the impact on a child, if a child goes to a unit outside of mainstream education, and that might mean that they have no access to the full curriculum, or they're not in school at all, or even though this process is going to impact on my attainment. There's lots of statistics about that, adverse impacts, and all the other stuff about the adverse consequences that can arise. That's what you need to be saying is part of the disproportionality, because you've got to look at it in terms of what's the impact on this child. And it then does mean that those kinds of discriminatory elements, particularly on grounds of race, but also other protected characteristics, can have a cumulative effect, so that it's going to have a disproportionate impact on these groups. So that's what that means, and that was established, that we got that as a concession. But then what happened with the judgment is that it went further and established that if your claim involves substantive Equality Act breaches, arguably, so what obviously arises in lots of exclusion cases, you do have an issue to do with discrimination, and you argue that as a substantive discrimination, which it would be if they didn't properly take into account and identify or make provision for your special educational needs, or they didn't deal with an incident of bullying that had racist element to it, or you can show that there's disproportionality in the use of exclusion in that school. All of that is potentially a substantive breach of Section 85 provisions of the Equality Act. And the court ruled that that constitutes a determination of civil rights and obligations. And that was key, because that therefore means that Article 6 of the ECHR is engaged. So we based that argument on a Strasbourg case called Aureus, and Croatian, thank you, Ollie, which had said in terms that Article 6 is engaged in discrimination cases. What we lost on is that the PSED, so the Public Sector Equality Duty provision, which is the process provision, that in itself doesn't constitute determination of a civil right or obligation. So you can't just make your case on the basis of the PSED, even if it's part of your argument. That's not the basis on which you seek the funding. And the importance of that is that actually most PSED arguments can actually be substantive arguments, because again, you haven't properly considered the protected characteristic and its impact. So you just have to make sure you formulate it as a substantive breach. And in those circumstances, the key ruling that the court made was about whether or not the IRP makes a directly decisive determination. That was heavily contested by the LAA, and the judge concluded that it did. Basically was saying that it doesn't have the power to make a decisive determination, and argued that instead that would be something dealt with by the FTT or the county court. Court said no, clearly the IRP has that jurisdiction to determine. It can make an order quashing the exclusion or requiring reconsideration. That is a decisive determination, so Article 6 is engaged. That is an important decision. I have to say that in practice so far, we haven't had a single case in which the LAA has yet granted it. We've got a number of outstanding applications. They're fighting a rearguard action. And it's really important to make sure that your ECF application addresses these factors. And that's certainly something that if people are wanting to pursue this sort of application for funding, we would be happy to share templates of of the formulation, so that you can see, having learnt from the pushbacks that we're getting from the LAA, what it is that you need to make sure you say, so they can't knock you out on some kind of pleading point. And we're certainly keen to make sure that if you are seeking this funding, that you keep a record, and we try and monitor what is happening, because our experience to date is that there certainly is a strategy on the part of the LEA to delay. They fail constantly to do this speedily, even when the hearing is looming, or is, you're seeking it on an urgent basis. And what they're trying to do is to wait to see what the outcome is, and then to say retrospectively, well, you didn't really have this discrimination argument, or you didn't really establish a breach of Article 2, Protocol 1 retrospectively, when obviously that's not what it's all about. This is about a safety net to prevent a risk of an Article 6. And your arguments need to be, you don't know when you're doing your funding application exactly what's going to be your strongest argument, but it's something that you can say early on, these are engaged. So we're more than happy to share our experience of this, and I hope that despite the fact that we haven't yet got any funding and there are now PAT letters going out to challenge what they're doing, that people will be encouraged to take up this opportunity. So that's all that I'm going to say. In terms of questions, we're going to leave that till the end, and we'll obviously monitor the chat. We are going to record the session so that if anybody wants to contribute, they don't want that to be published in any way, just tell us in advance, because our plan would be that we would publicise afterwards the content of the seminar. So having set that out as the framework, we're now going to look at some of the substantive developments in the law, and we're going to hear from Nicola Braganza KC, who I'm sure you know from attending other seminars. She's a leading barrister practicing in this area. She brings to this area her expertise in equality and discrimination law, public law and human rights, and she's going to talk to us about the case law, recent case law on criminal exploitation and Article 4 and local authorities.
Thank you. All right. Hi, everyone. So I'm going to be speaking about two cases this evening, RWU and NAA, and Ollie was in both. So if I get anything wrong, I'll look to him. I'm going to start with RWU. It's now almost precisely the anniversary of RWU, and many of you may well be very familiar with it because it was really important in terms of setting out when Article 4, the protective duty, is triggered for schools. The outcome was about as disappointing and disheartening as it could have been for our client, but in terms of the wider importance, it's really helpful in setting out what the principles are that are to be applied. So, setting out the facts first, claimant was a 15-year-old black boy. He was permanently excluded on the 18th of January, that should be 23, by the principal of the academy. He'd started in year 7 when he was 11, and then in year 10 when he was 14. Within a very quick succession, there were a number of incidents which gave rise to a suspension. So there was a change, a quite dramatic change in his behaviour. It happened within a very short period of time. And when we were presenting this, so I was involved, Ollie, initially Harry Harris and Alex Temple as well, we relied on all of these as indicators giving rise to the Article 4 duty being triggered. In terms of the procedure, he was excluded, disciplinary panel refused to reinstate. It went before the IRP. IRP was very critical, but mainly critical about the procedure, that they hadn't considered the proper policies and that there weren't notes taken of the decision, and also that there wasn't enough of a curiosity that was demonstrated, but that wasn't that Article 4 specific. But in any event, sent it back to be looked at again. GDP, governing body, looked at it again and refused to reinstate. So that was the decision that we challenged. So next slide. I've just set out there very briefly, and you'll see it all happened within a space of 5 weeks. We're going to be sending out the slides anyway, so you'll have all the detail of that. But within a very short time, he initially, he was suspended for 3.5 days for swearing. Featuring also in the suspensions was that he'd fallen asleep when he was in the reintegration room. So again, we relied on a lot of this to say, actually, it points to the Article 4 duty. And then the actual incident, again, sorry, the date is wrong there. That should be, is that 24? It should be 20, no, that should be 24. He attended school and was found to smell of cannabis. He was searched. He got really distressed when he was searched. Next slide, sorry, I should have said that. Moved it on mine, but didn't ask you to, sorry. He got really distressed when he was searched, and then his mum came in, and there was a difference in what they said about cash that was found on him. He said that it was for a friend, and his mum said that she'd given him this money. And in any event, the decision that was then taken was that he was to be permanently excluded. He'd been suspended 5 times before, 6th time meant in accordance with their behaviour policy that was it. He brought Class B drug onto the school site. He was also found in possession of paraphernalia and cash. A managed move was set up, and as a result of that, the governing bodies panel was put off. But because he was then found in possession of a knife, it then took its course, went before the governing body. Within the judgment, so we went to the High Court and then the Court of Appeal, there was reference to various support interventions that were made, but a lot of these were much earlier on, not during the time of the relevant different suspensions, to set them out there. And then next slide, please. And this is what we were pointing to, that in fact, that's the first date that's in bold, prior to permanent exclusion, he had been admitted to A&E with a suspected knife wound, and then afterwards, but still before it went back to the governing body, there were 2 further A&E admissions. His social worker had raised at the IRP that there was a concern about that he was at risk of extrafamilial harm in the community. Afterwards, he was then arrested in Doncaster for a drug-related burglary. There was an NRM referral, which post-dated the exclusion, and initially positive reasonable grounds decision and then a positive conclusive grounds decision, but the positive conclusive grounds decision post-dated the Court of Appeal judgment. Next slide. So I've set out there, I mean, that's also, it's cited in both judgments, the definition of child criminal exploitation, which was within the school's policy and also reflected in the modern slavery statutory guidance. And specifically, again, as I was setting out, we relied on, if you look sort of halfway down, on indicators. And we said, if you look at all these factors, it must have been plain at whichever stage. And obviously we were saying, as events unfolded, these were further indicators of him being a victim of CCE, and that these reflected what we saw within the policies and with the guidance. So children who appear with unexplained gifts or new possessions, specifically children who associate with other young people. So one of his suspension incidents was that he'd been brought back because he was, during school time, he was picked up by the police, he was with a group of other children, and other indicators, children who suffer from changes in emotional well-being, children who misuse drugs, and you can see that children who go missing for periods of time. His mum had raised that she was really worried about him coming home late, leaving early in the morning. So we said that all made out that the Article 4, at the very least, given what the test was triggered. Next slide, please. Thank you. So everything happened within a very short space of time. That was one of the good things about this. So from the time that we lodged to the time that the Court of Appeal gave us its decision, it was about 5 months. It was listed for a rolled-up hearing, came before Mr. Justice Fordham. The Court of Appeal very much endorsed what Mr. Justice Fordham said. He granted permission, but refused the judicial review substantively and refused to grant us permission to appeal. We then went to the Court of Appeal, had an order for a rolled-up hearing. Lord Justice Singh granted permission for Black Equity Organisation to put in written submissions, recognising in the terms of his order the importance of the case, and then about as disappointingly an outcome you could get. In view of all of that, the Court of Appeal judgment, I don't know how many of you have read it, but it sets out the background, it sets out the framework, it goes to, I don't know, something like 20 or so pages, and then there's one paragraph at the very end that says, and so we refuse permission to appeal. So we spent the day arguing it, and then we get one paragraph saying it's just not enough to even reach the permission threshold. So as I say, incredibly disappointing, but our case was Article 4 positive protection duty was triggered at the time of the permanent exclusion decision, and certainly by the time of the remitted GDP decision, due to the clear indicators which I've touched on before, of CCE, and that Section 6 of the Human Rights Act, read with Article 4, which is the prohibition on forced labour, slavery and forced labour, public authorities owe a positive obligation to take appropriate measures within the scope of their powers to protect an identified individual in respect of whom, and again, we said it's a very low threshold, they are aware or ought to be aware of circumstances giving rise to a credible suspicion. And that credible suspicion test is taken from RANCEF and also TDT Vietnam. So next slide, please. So helpfully, in the wider context, Mr. Justice Fordham said, agree permanent exclusion decision should only be taken compatibly with the duty owed by the school to the pupil by reason of the HRA 98. Also helpfully, I would also agree GDP could not fail to reinstate. So the Court of Appeal, he was effectively saying that if it is triggered, then the GDP could not fail to reinstate, which the Court of Appeal rode back on in its judgment. But then he says, on a case-specific basis, there may be cases where the same circumstances which would trigger an Article 4 protection duty, which would have become an obviously relevant consideration to which regard must be had. Judiciary could look, the court could look objectively at the trigger test, cannot be an exercise in hindsight. So all of that is very helpful. And I think the big message from that is, if in your conduct of these cases, you take the view that there's evidence making out indicators of Article 4, that is raised as soon as possible, because there was also some discussion on ours about the extent to which we had raised it at the earlier stages. So raise it as soon as you can, be clear about it. Next slide, please. And so he went on to set out what the positive duty requires. And again, it's the is aware or ought to be aware, and NAA picks this up, the next case that I'm going to be speaking about as well. And he held, court has to look through the prism of what the Academy knew or ought to have known. The Academy was alive to the issue. IP was satisfied the Academy had taken CC into consideration. And he said, and I have to say I disagree with this, because he, informing his analysis, was that the factor that neither the LA nor police considered the CCE positive obligation. And I have to say I disagree with, just because the police in LA didn't consider it, I don't see that, how that is necessarily determinative or can justify a school not picking up on it. If the indicators are there, they're there. Right, next slide, please. So went to the Court of Appeal, and again, for our individual RWU, it was a terrible outcome in what the Court of Appeal found, but we now have, at Court of Appeal level, Lord Justice Bean setting out, so you have it there, there's a potential issue as to whether on judicial review, the first thing is what the court is looking at of an exclusion decision where an ECHR issue is raised, whether the court should make its own objective evaluation. Now, pausing there, Mr. Justice Fordham said, yes, it does. As to whether at the relevant date the circumstances gave rise to a credible suspicion of a real and immediate risk of exploitation. Fordham J proceeded on the basis, more favourable to the claimant than the alternative, that the court could look objectively at the trigger test, while emphasising this could not be an exercise in hindsight, which is what I referred you to on the previous slide. We proceeded on the same basis, and it was not suggested we should do otherwise. Helpful. Next slide. So we had really strong, compelling statements from Quorum and BEO, and I think, I was just checking that, but I think that the BEO submissions are actually on their website. And again, if you are running these cases, they're really comprehensive and very, very helpful, and I would draw on them as well, raising your own Article 4 points. So, and he set out, for my part, I would readily accept what they say, but these factors are inherent in the balancing exercise laid down in the various policy documents we were shown. Excluding the child may well be harmful to his life chances and increase his vulnerability, which is why permanent exclusion should be a last resort, but allowing him to remain until return to the school may create a serious risk to the welfare of other pupils. Helpful. Next slide, please. and this is again the test about credible suspicion. There is now no dispute. So I suppose this would be the key paragraph we would rely on in saying Article 4 is triggered. And that's where this case does make a significant difference. And referring to TDT and RANSEF, he says whether the state authorities are aware or ought to be aware of circumstances giving rise to a credible suspicion. And in the next case that we look at, this is then picked up again on Article 4. It's not sufficient to show in the case of a school a risk that permanent exclusion will increase its vulnerability. So that is RWU. NAA, next slide please. So this was a rolled up hearing in front of Upper Tribunal Judge Ward, sitting as a High Court judge, and concerned the interaction between protective mechanisms under the Modern Slavery Act and the procedures which resulted in decisions to permanently exclude. It's something like 65 pages, which is a little bit off-putting. So I volunteered to speak about this without checking the page number first, but there's a lot of it in the judgment that isn't Article 4. There's about delay, there's about would the outcome have been the same, so Section 31. There's a lot about the need for clear pleading. So you can just, when you strip away all of the extra parts, it's not that overwhelming to read the Article 4 relevant bits of the judgment. And so in terms of the facts, so this was almost the opposite of RWU, because everything was set out here in advance in its starkest form. Claimant, the incident was that he's year 10, pupil selling drugs to another younger pupil and then sending explicitly violent threats by text message and voicemail to that pupil when seeking payment. Immediately raised by the assistant head teacher in Senko of Haringey Learning Partnership. So claimant was then a 1-month respite placement, and there had specifically been referenced by his mother referring to previous attempts made to recruit C to county lines, but at that stage they said that they managed to thwart those attempts. So spelt out as much as it could have ban spelt out. There was a risk assessment, assessing C at level 4 risk of significant harm. Next slide, please. I'll speed up a little bit. Got 4 more minutes, 2-3 more minutes. And then again, in stark contrast to RWU, so AH, assistant head teacher, said, we are incredibly concerned A may be being groomed, may be grooming other vulnerable younger students. It's a danger statement from the social worker, continue to be groomed, manipulated, exploited if he does not engage with services to prevent this. The index incident is then in March. There's a positive reasonable grounds decision, 22nd of March. Next slide. And then you see there the procedure: excluded, reinstatement refused, IRP upholds it, positive conclusive grounds decision. And the positive conclusive grounds decision is that C is a victim of modern slavery in the form of CCE by way of forced drug dealing. The challenge, so this is now breaking down what the judgment sets out. So the challenge was brought to the IRP decision. Next slide. Thank you. Challenge was brought to the IRP decision. Permission was granted on that, but it was dismissed on the merits, so forget that. Challenge was brought that the local authority had breached its Section 52 duty under the Modern Slavery Act, and I've set out there what Section 52 says, which is that the LA has got to, it must notify the Secretary of State, or section applies to, among others, London Borough Council. And next slide, thank you. So it's the IRP decision, irrationality, Section 52 and the Article 4. So for our purposes, 8 breaches were relied on, and the ones I've put in bold are the ones that were made out. So he got his declaration that the LA had acted in breach of its Article 4 duty. And the others had permission refused on the basis of pleading points that were taken. So you see there, failing to discuss the situation with the school was a breach of Article 4, failing to notify the school about the RG decision, failing to tell the GB about the RG decision. Next slide. So there I've just set out why the judgment dismissed the claim on section 52. It was brought too late, but had it not been brought too late, the breach would have been made out, would have been accepted as having been made out. And the judge set out, there's a duty acting rationally in the legal sense was to decide upon whether it had reasonable grounds to believe that a person may be a victim of slavery or human trafficking. That involved distinguishing between mere allegations and those with sufficient foundation. I note the wording is maybe, so that's important. That goes back to the credible suspicion test. Maybe, not is. And the court found the local authority had the evidence for this. Next slide. And again, I've cited that. I don't need to read that out. Basically, Upper Tribunal Judge Ward said there's more than enough evidence here making that out. Next slide. So then we get to the Article 4. Duties under Article 4 had been triggered for the same reasons as the Section 52. If not earlier, then going down the chain of events, then certainly by the time that the SCA had notified Haringey of the RG decision, there's no lack of promptness, but there was an extension granted of 24 days. And Section 31 was not made out. The judge found that you couldn't say that it was highly likely the outcome would have been the same. No award for damages because the judge found that the declaration that there had been a breach of Article 3 on those three parts was enough, was just satisfaction. And then two final slides, and I've cited them in their entirety because I think these paragraphs are really important. First one, to downplay, so this is really important because the reasonable grounds decision, so that's the first stage, to downplay its importance for that reason is to ignore the position of the SCA as the central specialist decision maker who may be assumed to be able to bring to bear the experience gained from making large numbers of such determinations. And I'll leave that there for you to read if you go back to these slides. And the very final slide, and then I'll wrap up. And I think, again, this is really important to highlight the vulnerability of the clients that we're representing in these matters and the seriousness of Article 4 and CCE. And that is, the claim involves important issues of human rights in a context which is the source of considerable concern, and in particular how the mechanisms respond where the potential, and as it turned out, actual victim is a school pupil, which is what we had in RWU, but post-dating it in the starkness that we have here in NAA. Although some of the issues in the case could be seen as practical operational, arising out of the local authority's apparent failure to file properly or otherwise heed the notification of the reasonable grounds decision, others are not. In particular, the local authority's failure to discern from the material available to it, the school should have been informed of the existence of reasonable grounds. So two really, really helpful cases I urge you to basically go back to when you have concerns about CCE and Article 4. That's it. Thank you.
Excellent. Thank you, Nicola. So just 2 points on that would be relevant to if you were making an ECF application where there was an Article 4 criminal exploitation issue, is that you've got in paragraph 34 of Lord Justice Bean's judgment in RWU issues about impact. So that would be important as well for looking at the disproportionality. And you also have the fact that it's clearly established that human rights are engaged in that, and that would be a basis on which you would seek ECF funding under Section 10. So those are links to my submissions, to my presentation. There's also a link in that, obviously, as to the court's approach, which Ollie Persey is going to develop and give you further information about other cases. I don't think Ollie in this area needs any introduction. I think we both recognise he's a powerhouse in this area and is making an important contribution to the development in the law in many areas, judicial review before tribunals and on a policy basis. So with that introduction, you can tell us what the situation is with the intensity of review.
Great.
Discrimination.
Thank you very much, Steph. I'm going to be speaking to two Court of Appeal cases. First is TZA against a secondary school, and the second one is SAG and Winchmore School. Both losses, but there are useful learning points from them. So the first case, next slide please, is TZA, and okay, PSED dead in the water is maybe not the most promising start for a discussion. I don't think it is the conclusion. You will all be familiar that there is a two-stage process for permanent exclusion, or what has been called a necessary precondition. So it's a two-part test that a head teacher needs to satisfy. That it needs to be in response to a serious breach or persistent breaches of the school's behaviour policy. And the second part, and this is the most material part, which is often referred to as the risk assessment, where allowing the pupil to remain in school would seriously harm the educational welfare of the pupil or others, such as staff or pupils in the school. Now, the too long didn't read analysis of TZA is PACD, you may be overcomplicating it. You should be taking into account all considerations when you are looking at the risk assessment anyway. And that does not mean that you cannot run equality-related arguments, procedural equality-related arguments, when challenging a permanent exclusion. The nub of TZA is fold those arguments into your arguments about Limb 2. Don't do it as a bolt-on, and/or run a substantive ground, not just a procedural ground. One of the things that has been gratifying to see post-TZA is a change in practice in IRPs more explicitly asking about equalities information. One of the main providers of IRP services has now added a specific question, and that was the provider that was at the heart of the JR. So I don't think it's necessarily a coincidence that that has happened, and it expressly directs independent review panels to consider equalities considerations in more detail. But we all know, taking a step back, that there are structural disadvantages facing certain groups at school, and there is a disproportionate level of permanent exclusion in respect of certain groups, in particular in respect of special educational needs and disability, and in respect of certain racial groups, Gypsy, Roma, Traveller being the number one most excluded. That is all important context to a risk assessment and an assessment of whether it is really a last resort to permanently exclude a child. Because if it is known to a school, or if a school should know and should go through the processes of understanding that there are certain children at higher risk of exclusion because of structural disadvantage, if the school has not turned its mind to it and tried to address it, then it will have difficulty establishing that permanent exclusion is a measure of last resort, potentially, and it goes to whether it is undertaken a proper risk assessment. Could there be measures that it could take to reduce the risk of the child remaining in school? The second limb is a forward-facing limb, where allowing the pupil to remain in school would seriously harm. Okay, well, there's something has gone wrong, but this is a pupil who has structural disadvantage. Have you turned your mind to the need to have due regard to eliminate discrimination, foster good relations, and promote equality of opportunity? What steps have you taken? So if the PSED is not dead in the water, next slide please, but it does, the court was reluctant to have an overly technical approach to the PSED and trying to make head teachers jump through hoops to establish whether there'd been a breach or not. But proper actual understanding of the circumstances of the child, which will be informed by their background and their protected characteristics, remains vitally important. Next slide, please. So, intensity of review, and I'm going back to the RWU case as the first slide, which Nicola has already spoken to. And this was the first exclusion case that I'm aware of where we started to run arguments in respect of the importance of anxious scrutiny. So intensity of review is about how closely the reasoning of a decision maker will be examined. And we argued, applying a case called KM against Cambridgeshire from the Supreme Court, which was in relation to a disabled child's social care, that a similar approach should happen of close reasoning, close scrutiny from the court because of the profundity of impact in relation to a child if they are permanently excluded, which is why all the evidence from Quorum, Black Equity Organisation, etc., about the profundity of impact of permanent exclusion was so helpful in Court of Appeal and has been helpful in other cases since, is because it establishes this is a measure that has a profound impact upon a child. The evidence of the school to prison pipeline is truly shocking for anyone that works in this field, something that they will be very familiar with. The mental health impact, Mind intervened in the CWJ case that Steph has spoken to, setting out the mental health impacts of permanent exclusion. We're through all of this case law. One of the good things is it's now on record in judgments. Nicola highlighted it in relation to RWU, that exactly how harmful permanent exclusion is. And it now appears to be almost common ground. I'll speak to what happened in Sag and Winchmore shortly, that generally the profundity of impact of permanent exclusion equals high intensity review. And that is a very helpful starting point because it narrows the range in a substantive rationality challenge. It narrows the range of reasonable responses of a decision maker. And in a process irrationality challenge, it requires the court to consider every factor that could weigh in favour of a claimant. So next slide, please. So SAG and Winchmore, this was a 2-1 split, and Alison's in the room, so please correct me if I get anything wrong. He was my brilliant instructing solicitor on this. It concerned the permanent exclusion of a child who retrieved their mobile phone from a teacher's room whilst on a school trip abroad, and very sympathetic facts. Child had recently had a bereavement, mother had had cancer treatment, her dad had recently died, her mum had recently undergone cancer treatment. She was permanently excluded for this serious one-off breach. And it went to the IRP quashed and sent it back. And in making the new decision, there was a clear error of law in that they found her guilty of burglary when that doesn't fulfill the criminal criteria of burglary. So next slide, please. So judge accepted, much to the annoyance of the defendant's barrister, that intense review should apply, but much of his analysis looked like I applied intense review rather than it was a sort of box ticking exercise rather than a matter of substance. Adopting a more, he said words of that, I applied intense scrutiny, and if I'd applied more benevolent, if I'd taken a more benevolent approach to the defendant, I would have reached the same conclusion. Like, this didn't actually apply intense scrutiny in substance. He essentially finds it wasn't a material error and that in any event, the section 31(2)A, highly likely to make no difference test was made out. And then next slide, please. So these were the grounds of challenge. And then one of the grounds of challenge was failed in substance to apply the required high intensity of review. Final slide, please. We lost 2-1, which was really frustrating. And Lord Justice Edis was with us, and he was notably the only judge with a criminal law background. Yes. So what he allowed the appeal on all 3 grounds, and actually most of the heavy lifting of his analysis was done on this intense scrutiny point. And it provided a gateway for him to actually laser in and adopt a more critical approach of the underlying reasoning of the governing body. So I think the key takeaway of this is please keep arguing for intense scrutiny. There is good case law on intense scrutiny in the courts at the moment. There's been ultimately unsuccessful but helpful on this point Howard League challenge to the use of pepper spray in prisons, which at paragraph 91 really helps on the importance of intense scrutiny and also distinguishes between outcome rationality and process rationality and makes clear that an outcome rationality defence won't work for for a process rationality challenge, and that intense scrutiny means that every factor needs to be weighed in favour of the claimant. It's still lost, but it is a helpful development when you're concerning the treatment of vulnerable children to have this scrutiny, because sometimes it can feel like there is complete deference to a head teacher, complete deference to a governing body. This, at least, this strand of reasoning, which has been adopted and applied in the case law, means that there is higher intensity of review and therefore better scrutiny, and it's not the hands-off deferential approach to reasoning that we might have seen previously. So, thank you very much.
Thank you, Ollie. So we're next going to focus on the use of isolation rooms, and Michael Etienne, who's I think it was Michael that's going to be next, is joining us online. He's going to speak to this important topic. Michael is well known for his work also in education law, again covering all courts and tribunals, and particularly focuses on the discriminatory elements in education law and practice, using his expertise in policing and prison law to particularly focus on challenging exclusion as part of what we've heard regularly as the school to prison pipeline. And that's a significant part of his work. But today he's going to focus on isolation rooms.
Hi, everyone. Thanks very much, Steph, for that introduction. I'm sorry that I can't be with you in person, especially because it means you have to look at an even bigger version of my face on a big screen. So Ollie, having set everyone up to be more enthusiastic about the lack of deference in the courts to the professional expertise of head teachers, has given me something of a hospital pass in relation to the case that I'm discussing, which is a case called EBB, LAX, and LUN, all by their litigation friends, because they were three children challenging the use of isolation against them in a school run by the Gorse Academies Trust. I haven't done a PowerPoint presentation for this, so if you want the reference, it's 2025 EWHC 1983 admin. As I've indicated, essentially this was a challenge to the use of isolation, and it's important for discussion purposes and also in understanding the judgment that obviously isolation is a sanction short of exclusion. And as many of you probably are already very familiar, there has been for a long time a real concern about the regularity with which children are being put into isolation as part of their school discipline policies. And this case was viewed by those of us watching closely as a test case on essentially on that broad issue, although when you read the judgment, and you might pick up hopefully from my summary of it as we go through it, this was from a legal point of view, a very technical challenge, but the essence of it was about the use of isolation. And thank you to Ollie for putting a link to the judgment in the chat. So just to summarize the position of each of the three claimants, to really put all of this into context, essentially there were three children who are named and given pseudonyms in the judgment. One who'd spent 83 days in isolation for the 2023-24 academic year. And I'm going to assume it wasn't counselled, no offence to Dan Squires and his team, who did the maths to work out how much time in the academic year each of the pupils had missed in isolation. So the first people had spent over 500 hours, which represented 43% of the academic year, which was in addition to 14 days of suspension. So what was happening in this case was that the academy policy was that if you were excluded for a period, there was essentially a mandatory period of isolation as a reintegration period. so what you have is obviously the period that you're out of school, and then the period that you're technically back in school, but still in isolation. So 43% of the academic year for the first claimant. The second claimant, 43 days in isolation in 2023-24, which was 279 hours, which was 26% of the academic year, which was in addition to 20-day suspension, meaning that they had been either isolated or suspended for 40% of the academic year. And the third claimant, who had spent 28 days in isolation in the academic year, which represented 180 hours, which was 17% of the academic year, which again was in addition to 44 days suspension, which meant that she had been either isolated or suspended for 44% of the academic year. So in almost two of those three cases, pupils facing what I'm going to call de facto exclusion from school for a period of almost half the academic year, the second claimant being a bit less than that, 40%. So there was a lot of hope that this was going to be a case that would really challenge this use, which everybody obviously understands is a wider issue. Unfortunately, I have to give you the spoiler alert that the claim on its facts was not successful. The claim was advanced on 5 grounds. I'm not going to deal with all of them, but just so that you have a sense of what they are. Ground 1 essentially was an argument that there had been a breach of statutory duty. So the relevant piece of legislation that deals with sanctions short of exclusion is Section 91 of the Education and Inspections Act 2006. And it was argued that by failing to consider whether repeatedly imposing the sanction of isolation on the claimants constituted a proportionate and otherwise reasonable punishment, there was a breach of the duty. Second, an alleged failure to follow the non-statutory guidance. So there is, as you will know, lots of statutory guidance in relation to discipline in schools. The principal guidance relevant to this challenge was the Behaviour in Schools Advice for Head Teachers and School Staff, issued by the Department of Education, most recently updated in February 2024. Ground 3, breach of the statutory duty imposed by Section 91 by imposing disproportionate and otherwise unreasonable disciplinary penalties. Ground 4 was a challenge under the Human Rights Act that the use of isolation in the facts illustrated by this claim was a breach of Article 8. And then ground 5, allegedly an inflexible application of the school's discipline policy to one of the pupils in particular. I'm going to deal just with grounds 1 and 5 1 and 4 in substance. So the point about the arguments around the statutory duties attached to Section 91 of the 2006 Act and the court's approach to the arguments and the court's approach to the human rights claim in ground 4. So when you look at the judgment, you'll see that it sets out Section 91 in full, and essentially Section 91 sets out a number of conditions which have to be satisfied by any disciplinary sanction in order to be lawful. And it will become important to note that the way that the statutory provisions work is that the focus at face value is on the particular sanctions that are imposed at particular times, whereas part of the claim that was advanced in ground 1 was that there was essentially a procedural obligation on schools to also consider the cumulative impact of using isolation. So the way that it was put essentially was that there was a requirement to consider the impact of the sanction on the pupil, its likely effectiveness, and review the alternatives available to a particular sanction, as well as looking at the substance of the decision. So the substance of the decision really turns on the detailed elements of Section 91, and the real key part of that provision in this case is that one of the conditions for the lawful imposition of a penalty short of exclusion is consideration of any special educational needs. The other factors are the pupil's age, any disability he may have, and any religious requirements affecting him. But in these cases, the focus appeared to be around the extent to which consideration had been given to special educational needs. It's important to understand also that the way that the challenge was run was relatively narrow, in the sense that there was no challenge to the school's behaviour policy itself. It was accepted that the policy in and of itself was lawful, subject to the questions essentially of statutory interpretation and compliance with the HRA for the purposes of our discussion. And it was also essentially accepted that the individual sanctions were in and of themselves lawful. The real focus of the claim was about the cumulative impact of all of these sanctions. And it's important to say, although time doesn't permit me to go through all the detail of it, it's clear from reading the judgment that each of the pupils who had been the subject of sanctions had very difficult and challenging personal and educational experiences, lots of records of what schools would call persistent misbehaviour, incidents of serious violence, failing to attend consistently at school, and so on. Essentially, lots of the sorts of challenges that children, young people and their families often face when we're talking about cases concerning school exclusion. So, was there a procedural duty? So was there an obligation on schools to consider essentially the effectiveness, the impact of a sanction, and to consider alternatives available as a freestanding procedural obligation essentially implied in Section 91? And the reason I say implied in Section 91 is because the judge made it quite clear that on a plain reading of the relevant statutory provision, there was certainly no express duty. So this was a judgment of an experienced High Court judge, Mrs. Justice Collins Rice, and she essentially said there was nothing ambiguous about the drafting of Section 91, and there was nothing which necessitated essentially reading in this procedural obligation. And in a theme that runs through this case, and anyone who's following the judgment, looking at paragraph 75 and 76 in particular, where essentially what she's talking about is there's no ambiguity in the drafting, no space, and certainly no necessity for inferring individual procedural duties about how disciplinary decisions are to be taken in schools. And goes on to say essentially that the existing framework of Section 91 sets out essentially mandatory considerations. Those considerations necessarily require some regard to be had to the impact of sanctions by reference to the conditions such as disability, SEND, age, and so on. And described the existing framework essentially as being giving rise to a substantial jeopardy which schools need to manage strategically with their policies, procedures, and training. But the statute shows no sign of trying itself to control how that is done, much less to control the procedure at the level of individual decision making. And essentially what we can see here is the court essentially saying it doesn't want to descend into essentially micromanaging the decision-making of schools, but also that there's a need to bear in mind that although this challenge obviously arose on the individual facts, the statutory provisions have to be capable of applying to a whole range of situations. And one of the problems in the court's view of saying that there was this procedural obligation is that it would potentially complicate how decision-making would happen essentially in real time. There is, in the course of this kind of discussion about essentially the court's deference to the judgment of teachers and education professionals, reference to another decision, which we're not dealing with discreetly, but I always worried when it came out that it would be cited often in similar cases, and it's the case involving the Michaela Community Schools Trust in a case called the Crown and TTT, which is a decision from 2024. And essentially in that case, Mr. Justice Linden talks at length about the need to give deference to schools, and at paragraph 125 of the judgment, we can see reference to that judgment again, citing where Mr. Justice Linden said, ultimately, the question is whether the measure in question is proportionate. That is for the court to decide. In arriving at an answer to that question, however, the court will make allowance for the breadth of the decision-making power conferred on the decision-maker by Parliament, and it will be appropriate to give weight to the relative expertise of the decision-maker where they have made a judgment on an issue which is within their sphere of expertise, even if that judgment is made after the event. All other things being equal, the better the quality of the decision-making process, the greater the relative weight to be attached to the expertise of the decision maker, and vice versa. So the judgment then goes on to consider whether rejects the argument that there's this procedural obligation, and then goes on to consider whether in the individual circumstances of each of the claimants, the requirements of Section 91 were satisfied, and essentially the court found that they were. Skipping over the other grounds and turning then to the HRA claim, the argument was, as I said at the beginning, that the use of isolation in the way that gave rise to this claim engaged and breached Article 8, essentially because it was argued Article 8 includes the right of individual pupils to maintain relationships with other pupils, and that the disruption to their education was essentially a violation of that right. Very disappointingly, the court said that Article 8 wasn't even engaged. So there is reference to a very old judgment called Costello and Roberts, which is a case in which Article 8 was found to be engaged, wasn't found to be engaged, but that was a case about corporal punishment. Obviously, the jurisprudence of the Strasbourg court moved on over the years after Costello, and there's a different judgment. There are later judgments which obviously find that corporal punishment can give rise to breaches of the convention. And there was also another case called FO in Croatia, in which a convention breach was found. But in that case, it concerned essentially verbal abuse and insults by a teacher of a pupil in her class. And so Mrs. Justice Collins Rice went on to essentially distinguish the engagement of Article 8 that had been recognised in the FO in Croatia case, saying that the Strasbourg court in FO in Croatia affirmed the principle that some, but not all, of what happens to young people in school may engage their Article 8 rights. The case is not authority for a proposition that discipline in school as such generally engages Article 8. On the contrary, the court clearly affirmed that school discipline is in general intrinsic to education itself, part and parcel of the inevitable interference with a child's autonomy entailed by sending them to school at all. Which unsurprisingly doesn't harbour well. So you can see what the direction of travel is when we come to look at how the court approached the application of Article 8 on the particular facts of this case. Now, as it was mentioned in the introductions to tonight's events, obviously one of the issues that we're really concerned about is essentially the relationship between school exclusion, social exclusion, and exposure to the criminal justice system, the school to prison pipeline. And in this case, there was an attempt to make that connection, to connect the use of isolation by drawing analogy with the negative impacts of segregation in both the prison context and the immigration context. Unfortunately, the court considered that this was, quote, an ambitious attempt, and that you couldn't draw that analogy. The judge went on to say, I do not think it is at all straightforward to extrapolate from what happens in state detention to what happens in a school. In Costello Roberts, that concerned a surrender of a substantial measure of the child's autonomy, and the parents' control to the school was critical, but that was in the context, in a different context, in terms of physical chastisement. And the court in this case said that it was obviously fundamentally different than examining the situation as it pertains to the use of isolation. And again, paragraph 164 of the judgment goes on to say that it is a feature to which the UK authorities keep returning. So this limited idea of freedom of choice, this limited notion or limited idea of parents, young people being able to challenge the decision making of schools in relation to behaviour standards, uniform policies, and so on. Saying is a feature to which UK authorities keep returning to in the Article 8 context, where school uniforms and other policies have been challenged on religious grounds, and again cites the unsuccessful claim in the Michaela Community Schools case, before saying the starting point where children and parents challenge the compliance of a school policy or practice with their human rights is that they have opted to go there and they have alternatives. Of course, that is only a starting point. It may turn out that the alternatives are not realistic or have other problems associated with them. These are, however, factual matters for a claimant to establish, which were not raised in the present circumstances of EBB and their fellow pupils. And went on to talk about how this was another school in which a lot of emphasis had been placed on a very intentional discipline and behaviour standards policy. This school also placed heavy reliance on its commitment to providing stability and predictability for children from potentially challenging or troubled backgrounds, quote unquote. Which rather than indicating that their approach in these particular cases was disproportionate, in fact encouraged the court to give particular weight to their judgment. And it's fair to say that in reaching those conclusions, the court also noted that there was some evidence that the approach that the school had taken was positive, both in terms of the circumstances of the individual pupils, some of whom had demonstrated improvements in their behaviour, but also as part of the wider consistency of discipline in the school. Now, one of the points that arose in response to that from the claimants was to say, well, actually, if you look at it, the improvements or so-called improvements in behaviour and so on could be tracked to the fact that they brought a judicial review. That was flatly rejected by the academy, and the court said essentially that it didn't accept that, and that if there was to be a claim or an argument of that nature, the court wasn't prepared to find it by inference. And in any event, the fact that there was positive evidence to the contrary suggested that that wasn't sustainable for the purposes of this claim. It went on to say then that the engagement of Article 8 was both unprincipled and unprecedented, and that it would offend common principles of Strasbourg jurisprudence about not going further than the Strasbourg court to hold that Article 8 was engaged at all, the so-called Uller principle, and just for good measure, went on to say that even if the court had been required to determine the question of proportionality, it would have found that the interference was proportionate because it's necessary to take account of all of the things I've touched on already, which is not only the concerns or negative impacts identified by the claimants, but the evidence of positive impacts both for the individual pupils and the school, and in the wider context, essentially, of parents essentially having choices about where they send their their children to school. Now, obviously, the question of choice, although this is kind of alluded to in the judge's reasoning, is often an artificial one. And that in itself is problematic, and it's unfortunate that seems to be being increasingly embedded in the court's approach to these issues. What then are the implications of this? Which I'll just scan through briefly because I'm probably already speaking over time. It's obviously another disappointing decision, but I think in kind of mitigating that disappointment and the discouragement in the judgment, I think it is quite important if you're facing claims of this type to look at the judgment itself. It is in some important senses very highly fact specific. And although there are questions of law that arise both as to the statutory construction of Section 91 and the engagement of Article 8, certainly on the engagement of Article 8, that's always essentially what they're saying is it's a fact-specific scenario. And it doesn't arise without more just because there is some interference or alleged interference with a child's engagement with regular school provision. And so then I think it's also worth saying that there are circumstances that I can see just taking the judgment at face value where things might be different. So, for example, if there were underlying challenges to the lawfulness of the discipline process, in this case there was no evidence of psychiatric harm or substantial harm in the sense of the application of isolation being so disruptive as to amount to psychiatric harm. Of course, there are circumstances where that might be different. I also think it might be different where it could be sustained that the impact of all of this aggravated a child's disability or SEND needs. And I also think it's worth thinking about whether or not the fact that it was in the admin court, this was a judicial review, also has an impact on how this challenge unfolds. There's a lot of rehearsal in the case about arguments about what the scope of the case was, issues about what evidence was or wasn't accepted, whether or not there should have been applications for extensions of time in relation to certain allegations and so on. So I do wonder whether in a civil claim, and obviously I've described a civil claim, but I'd include a tribunal claim within that, some kind of de novo adversarial forensic challenge to decision-making, whether or not that may or may not make a difference. But it's obviously clear that the landscape is very, very challenging. But luckily, the School Inclusions Project is always up for a challenge. Mm-hmm. Thank you.
Thank you very much, Michael. Just to keep you updated, we've got one more speaker, and then we're going to obviously have an opportunity to ask some questions. So if you're online and you want to ask the question, if you could put it into the chat now so that we can be looking at that while we have our last speaker. And then for everybody who's feeling a little bit 7:30 after a long day at work, after the last speaker, we are going to have an opportunity to have a drink, and I think there's some food out there. So I hope that you will stay and to carry on the discussion after the questions. So now, if I can just go to Alex, who also is online. Alex Temple is also a barrister in Garden Court, but he was before that a solicitor practicing Byman solicitors with an expertise in education law. And he, like Ollie, is involved in pushing the law forward, in representing parents and children as well as NGOs in a number of different contexts relating to school, colleges, university and other forms of public organisations, local and central government in this area. And I think we have him online. The indication of his dedication to his subject is that he's actually in a service station in Carlisle, having broken down on his way back from Scotland. So I hope we are going to be able to see him shortly. Probably is in the Burger King.
No, that will be after this.
He's in his car.
Because, of course, I'd much rather be in chambers, and I do apologise for joining remotely, not least because I get the talk, but not the food and drink. Not that I'm saying that's the best
He'll
bit.
save you some,
But,
Alex.
thank you so much. Yes, thank you. So, thank you very much for that. I'm going to be talking about appeals in the upper tribunal concerning disability discrimination cases arising out of school exclusions. I've got 4 to cover, but don't worry, 2 of them are meaty and 2 of them are less, I don't know what the opposite of meaty is, unmeaty, I guess. So we'll start with the meaty ones. The first case is DJ, the proprietor of Wellington College. Last year, this is actually one of Ollie's, so thank you much for this, Ollie, not least because it was a strong success. In fact, out of the 4 cases, claimants were the appellants in all 4, and they succeeded in 3. So a really strong showing for claimant lawyers in exclusion appeals last year. This first case then, DJ v proprietor of Wellington College. Oh, sorry, I should say before I start, I also don't have slides, but I do have a briefing note, a summary, which I think might be more helpful when it's just a quick-fire digest of cases. So after this, everyone who's registered to attend will get the notes, so you will have a summary of all of these cases. So in DJ, there were 3 grounds, a single ground that succeeded, but that was the meatiest of the grounds, and it included 2 points, which were both really important and are points which are often the most contentious in Section 15 Equality Act claims. And that is, first, the causation element in Section 15, i.e. has the unfavourable treatment arisen in consequence of the person's disability, and the second is the proportionality assessment, or whether or not the responsible body can raise objective justification for the unfavourable treatment. So very briefly on the facts, DJ was a student at Wellington College, independent school. He was disabled, and that was not in dispute. He had ADHD, dyslexia, and dysphagia. He was regrettably the victim of a violent assault before his transition from GCSEs into A-levels. It caused him serious injury, and he was required to appear as a witness in the criminal proceedings, which understandably caused him to suffer trauma. He passed his GCSEs, but there was concern about his capacity to engage successfully with his A-levels. He was required to sign essentially a behavioural contract, a performance contract, as is described in the judgment, and it obliged him to meet certain academic standards, to attend supervised study and comply with disciplinary requirements, the disciplinary policy, to be specific. He started his college and regrettably was quite quickly accused of breaches of the policy. These included that he had vaping equipment, that he was a part of a group that subjected a female pupil to harassment, that he was then aggressive to a student who'd reported that earlier incident, and that he overslept, missed mandatory support sessions and other sessions. The RB barred him from returning to the campus and gave his parents a choice: either withdraw him or he will be permanently excluded. His parents withdrew him and then filed a claim for discrimination under Section 15 and Section 20 of the Equality Act. Section 15, the claim was rejected by the First-tier Tribunal. They found, first, that the unfavourable treatment, so his behaviour specifically, had not arisen in consequence of his disability. They found that it was more likely a result of his losing interest in the course and a determination to get his own way. The appellant appealed on the basis that the FTT had set the bar for succeeding in the course development of Section 15 too high, in seeking to find that that his disability was the only or major cause, rather than simply an effective cause of his behaviour, in order to establish the link between the two. On proportionality, the FTT did not follow the 4-stage structured approach to proportionality as described in Astor Communities v. Ackerman Livingston 2015. Specifically, the appellant complained that the FTT had not balanced the specific impact on the claimant against the purported benefit of the legitimate aim identified by the college. Instead, what it did was say that it was considered whether or not there was a less intrusive, a less obstructive means of achieving the legitimate aim, and in deciding that there wasn't, that was sufficient to establish that the unfavourable treatment was proportionate to the legitimate aim. And the respondent basically said the FTT had established or described that permanent exclusion is always a significant impact on an individual, and that was enough to establish that they'd done the balancing exercise properly. In judgment, the upper tribunal found on the causation element that the FTT had set the bar too high and had applied the wrong test, rehearsing what is well established by now, that the disability only needs to be an effective cause of the unfavourable treatment. There was some discussion as to whether or not the FTT had actually decided that it was decided it wrongly by setting the bar too high, or whether it was actually discussing the evidence of the expert in the case at the point in the judgment where it gave its determination that the claimant's ADHD was not the only or major cause. But in any event, the upper tribunal said, well, if that was the case, then it failed to address the specific test at all. And it did come to the quite firm conclusion that the FTC, in saying quite explicitly that ADHD was not the only, in quotation marks, the only cause, that, and dismissing the claim on that basis, that it has to have set the bar too high. And it simply never established for itself whether or not, or never asked itself the correct question, never established whether or not, if not the only cause, whether disability was an effective cause. So obviously, just really important to hammer home that the bar for causation is not so high. And the next case we'll talk about is also really helpful on the causation limb in relation to the burden of proof. But you don't need to go so far as to say, but for the disability, it wouldn't have happened. On proportionality, again, the upper tribunal said it acknowledged that the FTT had reminded itself that, generally speaking, permanent exclusion has a serious impact, but it had not undertaken the four-stage structured approach to assessing proportionality, and in any event, quite simply, had never decided for itself what the impact on the individual was, what the impact on DJ was, and therefore could not balance it against the legitimate aim identified, and therefore it could never have completed the proportionality exercise. In addition, it had never identified what the something arising from his disability was, and therefore could not conduct the proportionality exercise. It could not effectively focus its mind on what the impact was because it had not identified what was arising from his disability. There were two of the grounds which were rejected, but neither of them, they're both very much specifically on the facts of the case, and neither engage a particularly interesting principle, so I'm just going to sort of skip over those. So the second case, B and V, the proprietor of St Dominic's Grammar School, again, interesting conversation on section 15, this time in relation to the shifting burden of proof in the Equality Act under section 136. The question was, does section 136, does the shifting burden of proof apply to the causation limb or the causation component of the section 15 test? And the answer is quite simply, yes, it does. In addition, the FTT had asked itself the wrong question in focusing the causation question on the motives, the subjective motives of B. So when we get to the facts, you'll see that what the FTT had done is identified what B had said about her own behaviour and decided that from her statements, she had decided, she had intended to engage in the behaviour, and therefore it can't have been a facet of her disability. So B was a 5-year-old girl at a private grammar school. She had physical disabilities which impacted her coordination, but also SEMH difficulties. The school imposed 2 sanctions on her: a fixed term exclusion and a permanent barring from its after school club. It accused her of behaviour including physical violence, kicking, grabbing, scratching, slapping of other pupils. The FTT found that B was disabled, but it dismissed the claim. Now, it never discussed proportionality at all. It ended with the dismissal of the claim on the basis that the causative element had not been satisfied. It held that the parents had not shown the causative link because it said the behaviour, as I said, was intentional. In relation to the kicking, it said that there was insufficient evidence to overturn the conclusions of the responsible body. It made similar findings in relation to the grabbing and slapping, and summarised its finding that B's claim fails because they are unable to show the link between the actions of the responsible body and B's disability. Quite clearly, what it had done is taken the claimant's evidence and thrown that into the mix, and then decided on the balance of probabilities whether that was sufficient to establish the link, which was incorrect. What it had to do was establish for itself whether or not the claimants had discharged their duty to show the prima facie case, and if they had, then passed the burden in accordance with section 136 to the responsible body to disprove, which it did not do. Excuse me. Quoting from paragraph 28 of the judgment, the shifting of burden of proof does not only apply to direct discrimination cases, nor does it only apply to the issue of the reason for the treatment complained of. On the face of the statute, it applies to all forms of discrimination claim and all elements of the claim. Practically, what we can learn from this is it means the burden is, as with other elements of the claim, to establish the prima facie case for the claimant. The stronger the evidence, of course, the better. And if there's no evidence at all, then the shifting burden is unlikely to assist you because you won't have established the prima facie case. However, it's not going to be fatal to a claim, or shouldn't be fatal to a claim, that your evidence does not get further than establishing the prima facie case. As summarised in Field v. Pine Co. 2022, the employment context, but applied by Judge Stout in this claim, if there is evidence that could realistically suggest that there was discrimination, it is not appropriate to just add that evidence into the balance and then conduct an overall assessment on the balance of probabilities to make a positive finding that there was a non-discriminatory reason for the treatment. To do so ignores the prior sentence in Hewage. The burden of proof requires careful consideration if there is room for doubt. Regarding motive, the upper tribunal criticised the FTT for placing significant weight on B's purported motive for engaging in the behaviour. Paragraph 44, I'm just going to read this, sorry, because it succinctly puts it. Why reinvent the wheel? It said, subjective opinions as to someone's motivation for their behaviour do not take you very far in answering the question that the tribunal needs to answer. A person's disability may manifest in many different ways, including both in ways that the person in question will experience as apparently conscious decision-making and in ways that are unconscious. For example, a child with autistic spectrum disorder may find themselves overwhelmed in a social situation, unable to articulate their emotions, and thus respond by quite deliberately, or at least apparently quite deliberately, taking out their frustration physically on a person or object. The fact that the physical behaviour is conscious and deliberate and or retaliatory does not itself mean that it is not causally connected to the disability. So clearly, I mean, this is a question that comes up a lot. I've experienced it a huge amount. And I found that RBs might well try to turn the tribunal's attention to that question as if the question is determinative of the causative element, i.e., has the young person apologised for it? Have they said that they're given a reason for it? Therefore, they must have thought about the behaviour. Therefore, it cannot be a pass to the disability. Of course, that's not how neurodivergence works at all. And it's quite good to have a succinct quote about the nature of neurodivergent conditions and what it might mean for a young person, even if they are apparently taking responsibility for the behaviour complained of. So those are the two meatier. I'm just going to stop saying the word meaty. Those are the two bigger cases. Now for the two slimmer ones, which are really, really succinct. ABV governing body of Kingston Grammar School. This is really straightforward. It concerns the procedure rules requirement that before an order disposing of the claim is imposed, basically a judgment is imposed, that there is a hearing of the claim. In this instance, there had been 3 hearings, but one of them was on an interlocutory application, simply case managing how evidence is going to be presented to the tribunal. And then there was an adjourned final hearing because the judge had not been able to open the PDF file, the bundle, and therefore had not been able to read the papers, and so adjourned. And then at the final attempt at a final hearing, the appellant sought an adjournment on the basis that their legal team had resiled, had stepped down at short notice, and their counsel was not directly instructed, and therefore they were without representation against their wishes, sought an adjournment. The FTT declined that and instead decided that they would decide the case on the papers. And obviously the procedural rules require a hearing before that's done, or the consent of the parties. The the appellant appealed. The respondent said, well, there had been a hearing because there'd been a procedural, there'd been an application, a consideration for request for change. And the upper tribunal just understandably, and I think straightforwardly, said, no, it has to be a hearing where the cases of both parties are heard and ventilated, and then a judgment can be issued disposing of proceedings. The final case is the only one where the appeal was unsuccessful. I don't think it's going to have an enormous material impact for any of us here. It concerned the nature of a pleading, and in very, very brief, the appellants had applied for a nursery place for their disabled child, and the nursery had in January 2023, I'm sorry, this is NE and GE, the governing body of a primary school. Again, you'll have this with the note that's circulated afterwards. The parents had applied for a nursery place, and in January 2023, the nursery had said that they were concerned about the ability to meet need, and the parents had taken that to be a refusal and therefore unfavourable treatment. However, there's a factual dispute. The RB said that that was not the case. It was actually just consultative, and the placement remained open until April, when it finally was withdrawn on the basis of a breakdown in communication with the parents. The FTT agreed with the RB and therefore dismissed the claim for there being no unfavourable treatment. And the parents appealed, and they said that fine, even if the FTT's factual conclusion that there was no withdrawal in January 2023 and therefore no unfavourable treatment in January 2023 was correct, there was still a withdrawal. It just happened in April 2023. And so the FTT should have turned its mind to whether or not that was unfavourable treatment and essentially applied the claim or applied the tests, to the claim on that basis. The UT said, no, that's not the basis on which the claim was pleaded, and therefore there was no obligation for the FTT to consider it, which I think is pretty straightforward. Plead to your facts. And that's it. Those are the four cases from the upper tribunal and exclusions last year. Thank you very much. I know I think we're running over, so I'll just stop there. And thanks very much for your time.
Thank you, Alex, for over and above from your car. It's very nice to see you.
Thank you.
So we have got one comment and 3 questions online. So well, let's see if we can deal with those, and then we'll see where we go. So this is a question from Michael, and it's about the question of choice that you referred to, and whether what's being considered there is that the choice is to be homeschooling, or are they contemplating that there's other educational provision available? I hope Michael's still there, not now in his car.
No, I'm still here. So the court's discussion of choice is focused on choice of schools. One of the points that it makes is that there are other schools, and other schools may do things differently. I think in many cases that's going to be a distinction without a difference. But obviously in the context of homeschooling, then the parents, people with parental responsibility, have that by definition they're not subjecting themselves or their children to the authority of a school, and that was what the court was talking about when it talks about choice. I mean, it was essentially saying if you decide to send your child to a school, then you necessarily essentially agree to any interference that arises. In principle, you agree to any interference that arises from the routine application of policy, of behaviour requirements and so on. Obviously, that's not to the exclusion of findings of discrimination. It's just saying, as a general starting point, you pick a school, you know what its behaviour policy is, you know what its provision will be, because all of this stuff is in the local offer and the school prospectus. And therefore, it's much more difficult to argue afterwards that this was an infringement of any convention right. I hope that answers the question.
Thank you very much, Michael. And there's a question for Nicola. So it's really about the role of local authorities in these proceedings, and in our they were an interested party, but they didn't really participate, and that schools tend to blame local authorities, but then they don't get involved. So there's a sort of passing the buck that means that you don't succeed in the school. So I just wondered if you could give us some insight in what you think was the role of the local authority And what can we do to make sure that they do engage properly and address concerns relating to criminal exploitation of children?
So it was really disappointing that Southwark did absolutely, they weren't anonymised, were they? No. That they took no part at all, so right from the outset. I think you just tick the box that says not taking any part, and throughout both sets proceedings before the High Court and the Court of Appeal. What can you do about it? Well, other than doing what we did, which is to bring them in as an interested party and keep them updated, I suppose one other route would be to think about whether you want to bring an HR claim in the county court for breach of their Article 4 obligations, but of course that brings with it cost implications and, you know, further stress and proactive involvement and time scale for having that dealt with in comparison to a JR. So I don't think there's any other route that you can get more involvement.
I mean, the only thing I think I would really add to that is RWU, it was an academy. If it is in NAA, it was a local authority maintained school.
Yeah.
And where it's a local authority maintained school, it's an easier nexus to sort of attack the local authorities or failures. And one of the problems with academisation, where schools are not first responders, is you have this siloing where the local authority doesn't do its job and can say it didn't have enough information from the school, and the school can say, well, the local authority didn't make an NRM referral, so how were we meant to know that the Article 4 issue was engaged, which feels wrong.
Yeah, so that's hiding behind the arrangements. Okay, so we have one other question which was relating to the white paper, which I mentioned at the outset, where the document, this is at pages, if you want to look at it later, 72 to 73, puts quite a lot of emphasis on greater formalisation of reintegration support partnerships. So before exclusion, if there's been, which is often the case, isn't it, that you have these temporary exclusions, what's the process for reintegration? And it's looking like that's becoming a requirement for formal meetings afterwards, leading to an agreed plan and to follow-up duties. And the question really is about whether we think that would have a useful preventative impact, a preventative measure in enhancing accountability of schools that might mean that it's a form of early intervention and behaviour improvement with parents that could be contributing to reducing exclusion. Thinking about that, Ollie.
I mean, devil will be in the detail, right, about how it's implemented. Or any alternative to permanent exclusion open to listening to. The idea of greater planning and being more proactive at an earlier stage, pre-permanent exclusion, seems to be a good one. Hopefully, more standardisation of it will be a good thing, but I think devil will be in the detail.
Yeah, I suppose that's already
And they're
duty, isn't
consulting.
it? Yeah.
They're consulting, so.
And there is also already a requirement to do that, and often they don't. So I suppose if it's saying, well, you better do this, then okay, fine, do what you're supposed to do. But
it'd probably be better than putting them in isolation for 3 days.
Yeah.
It's the other way for some people.
Dealing with it, yeah. It won't be isolation though, it'll be a hub or a pod with a nice fluffy name, which is what they tend to do now to hide what those places are. And the last observation, which is really just a comment rather than a question, but it's been a feature of a lot of what people have been saying about the exclusion to crime routes and about the impact of isolation in leading, also contributing to that process. And just commenting on what we know and the increasing evidence of how children who are excluded, particularly when they're in pupil referral units, can be targeted for grooming and becoming subject to criminal exploitation, that is obviously something that the courts are being told about and are recording this information. The question is what action is going to be taken. Michael, you might have a view on that.
Just briefly, this is really difficult because I think it's important to bear in mind that schools have safeguarding responsibilities. And if there is real concern that a child is being exploited, criminally or otherwise, then there are legal obligations on the school to address that. So that's like the helpful part, and then the difficult part is that A, that doesn't always happen consistently, and B, as these cases show, we often don't get to really into the details of all of that until you're dealing with an exclusion. And I think one of the things that comes out for me in looking at some of these cases, where the courts are very slow to intervene, is it moves the emphasis down the kind of timeline in a way to really preventing the exclusion in the first place. And just to pick up the point about the reintegration consultation process, again, it's as you say, Steph, the similar things have existed for a long time. There's a formal reintegration process, for example, that has to happen after a permanent exclusion. And I think one of the real issues, which I think is quite disappointing that the courts haven't really been taken with at the moment, is the reality of the real and significant imbalance of power between pupils, parents, and their schools, especially in the context of those pupils who have records that the schools will emphasize, demonstrate long patterns of challenging and difficult behavior. And I think one of the big challenges for us is continuing to try to find ways to get courts and tribunals to really grapple with the reality of this power imbalance, because what it means is that the notion of choice often is illusory, it's not realistic. And if that changes, then perhaps we will see a different trend in the cases to come.
Right, thank you, Michael. And I suppose that the other thing about that is we've been focusing on access to legally funded services at the IRP hearing, but obviously if they were available early on to reduce that imbalance and to give parents the opportunity to get advice before their child is excluded, then that would potentially have a bigger impact on avoiding the exclusion in the first place rather than trying to reverse it subsequently. So we've had a long evening. Anybody got a burning question or which we can take now, and then you can ask them in the context of having a drink, but we're happy to answer some questions now. Yes.
Just a quick one on choice with regards to Michael's case. With the court making that judgment, it actually makes a mockery of the reality that parents are faced with in sending their children to school. There's literally no choice, effectively. You usually have one or two schools that you can send your child to, and you're lucky if you get into one of your choices. So it's not a real choice. And for the court to make it out like it's a real choice, make it out like there's a marketplace of schools that parents can send their children to, it makes a mockery of that whole process. And the second point is that even if there was a choice, is the court trying to say that, well, if there's a school out there violating your children's human rights, and you send them to that school, then you made that choice. It actually absolved the school of the responsibility of breaching human rights. So rather than looking at whether the school is actually breaching the rights of a child, and actually it is a legitimate comparison to compare isolation in prison population, removing inmates and prisoners from the general population and the psychological impact that has, and in school as well, and the victimization, the stigmatization it opens up the child to. So I think the court was really lazy and irresponsible in dropping that.
I think we're all going to agree with that.
Also, it's not the kid's choice, right? It's the parent's choice. It's the kid's human rights.
Yeah.
I was just about to say, actually, when it comes to choice, most parents, in our experience, because we advocate for parents, have absolutely no idea how to even choose a school. They take the Debbie down the road approach, which is basically, Debbie said, that's a good school, so I'm going to send my child there. Or they look at Ofsted reports, and neither of those are good ways to choose a school.
Yeah, and no school brochure says, by the way, if your child misbehaves, we're going to keep them in isolation for 83 days. They don't say that, do they? It's a power, but nobody thinks they're going to do that on a long-term basis. You have a question here?
Not a question, but just a thank you for a superb set of speakers, fascinating. And also just on behalf of the Education Law Association, just a quick plug to say next week we're hoping to do a lunchtime online talk on the white paper. We're in touch with a couple of barristers from these chambers and one Sergeant's Inn. So, do look on the website if that might be of interest next week. Thank you.
Question here?
Hi, I'm just interested in why you would say that it has been an increase in exclusions from schools. Some people would point to the fact of league tables and that you have public schools trying to compete with private and grammar schools. So, how was your response to that, and what exactly would you say is the reason for this increase in exclusions that we've seen recently?
I think the reasons for increasing permanent exclusion are complex. Under-resourcing of schools, inability of schools to meet special educational needs, failures of local authorities to proactively identify special educational needs and put special educational provision in place, lack of youth services more generally, and the austerity agenda more generally, contributing to how children's behaviour in school, number of children and free school meals is not a coincidence. If a child is in poverty, they're less likely to concentrate, and that can have behavioural sanctions. All of that is complex and intersecting. But yeah, we are at a really high level of permanent exclusion at the moment, and it's really sad.
I also think there's a difference you can see in head teachers' approaches to it. So you have schools with similar demographics and yet very differing exclusion rates. So I think that is another factor, which we saw particularly in RWU.
So I think there's a political underlying sort of message coming that schools are entitled to do this and that they need to deal with behaviour.
I was just going to add to that it does also link to Ofsted and their behaviour quality. So whenever a parent comes to us and asks, when we get lots of parents coming to us about exclusions, the first thing I do is check to see when the Ofsted is due. And a lot of times the Ofsteds are due for those schools that are more inclined to start excluding children because they don't want an Ofsted inspection to come and see that their behaviour policy isn't working. So they'll just get rid of the children that are problematic with them.
And the statutory guidance 3-4 years ago, there was a market shift, wasn't there?
That's what it said to them, it gave a green light to say.
Randomisation as well.
Agree. Yeah. And that's why I haven't looked at it in full, but that doesn't seem to be being addressed directly in the new white paper. Dan, do you want to say comment on that?
Yeah, just on the exclusion increasing. In some schools, just because there aren't permanent exclusions doesn't mean that kids aren't getting pushed out. So in the school, which was the subject of the EBB case, the whole academy trust had only permanently excluded one child in 12 years. They're very proud to say. In the particular school in the trust in which these 3 kids were, they had that year, I think, 27 kids put in the alternative provision, which was owned by the trust.
Yeah, that's the other way.
So you can't just look, you can't just look at the permanent exclusions. That is a lot of kids to push out of a school, and that excludes obviously the kids who had effectively stopped going there because of the way that they were being treated.
I suppose that is an important context now, isn't it? That you've got such large, I think it's 20% of kids are not going to school. So they're getting no provision. That's not a decision to exclude them, but what is being done to get them into appropriate provision.
And the outcomes for kids who are effectively off-site directed are no different to those for children who are permanently excluded. There's, effectively, we found government stats which set that out.
Yeah. Yes. So, any other questions? If not, then can I thank you for our speakers online, Michael and Alex, and for all those who joined us online and for your questions. There may be 2 more, but I think given the time, what we'll do is answer those and send out we'll send out any answers that we need to on that. And obviously there's a lot going on and there's a lot more always to do. And certainly if you're interested in participating in responding to the white paper, keep an eye out on the SIP communications, because we'll try to help to coordinate some responses, obviously, on some of the issues that are pressing that we've talked about today, and other organisations will be doing that. Hopefully we'll work collectively to at least try to engage to get something that really understands and recognises the true nature of the challenges that children and their parents face in seeking to access inclusive, fair and non-discriminatory education. Thank you very much.